So this question, if he doesn't have a deportation order, how can they take him? So that is, of course, a very good question. And hopefully the presentation today will shed some light on the situations when ICE can detain someone like this asylum seeker. We don't know much about this person's history, of course, but he may be subject to permissive detention under the statute. So they may detain him, or perhaps even mandatory detention, depending on his manner of entry and other factors. Okay, so let's start first with this concept of mandatory detention and what does it mean to be subject to mandatory detention. So when we talk about mandatory detention, we're basically talking about a legal regime or framework that certain individuals fall into where they must stay detained without the right to seek a bond. Okay, so that means that they will not be released on bond and do not even have the right to a bond hearing. So with some exceptions, that means they will remain in ICE detention during their entire immigration case, which can take months or in certain cases, even years, right? And detention is often under awful conditions, hundreds of miles from their families, with very limited access to counsel. And as we will discuss today, this mandatory detention can be triggered by a conviction or a criminal record, even for a minor criminal offense, but it can also be triggered by other factors, such as apprehension near the border and being placed initially in expedited removal proceedings, or by having a removal order. And the impact of mandatory detention is great because it can often cause people to give up trying to fight their removal case and instead ask for deportation because the conditions are so difficult. And unfortunately, at least with respect to the 236C statute, which is the statute authorizing pretrial mandatory detention, the Supreme Court has upheld the constitutionality of that mandatory detention statute. So that is not considered to be unconstitutional. We'll talk later. There's actually kind of more limitations put on post-removal order detention when it becomes prolonged and the person's removal is not immediately foreseeable. And there are situations when you can, in certain cases, challenge the constitutionality of detention, but simply the concept of mandatory detention, keeping people detained without the right to seek bond is, in fact, constitutional, as this court has said, unfortunately. So we're going to move to talking about basically three different types of mandatory detention. And these are situations where, again, the immigration judge does not have the authority to grant a bond or release to your client. So the first is going to be under 235B1. So this is when the statute requires the detention of all non-citizens who are first placed in expedited removal and then transferred to formal removal proceedings. Then there's 236C. This is the statute that requires pre-removal order detention of non-citizens who are inadmissible and deportable based on certain criminal grounds, okay? And then finally, we have 241A2. This is the post-removal order detention statute. So it provides for mandatory detention during the first 90 days after the removal order and is discretionary after the 90-day period. So we're going to dive into all of these in a bit more detail, and I'll turn it to Corey to talk to us about detention under 235B.
Thanks, Liz. Okay, so INA 235B gives us our expedited removal provisions and then who they apply to, and then it also mandates detention of those subject to expedited removal under 235B. So 235B1 applies to non-citizens who are initially determined to be inadmissible due to fraud, misrepresentation, or lack of valid entry documentation. So it covers both those who either arrive at a port of entry and maybe request asylum, for example, and also to those who enter without inspection and are thereafter arrested within 14 days and 100 air miles of the border. So both would be considered applicants for admission and would be subject to expedited removal and subject to mandatory detention under 235B1. And in the case of those who just arrived to the port of entry requesting asylum, for example, or after having attended a CBP1 appointment, they would be subject to this provision just simply because they lack valid entry documentation. So those who are covered by 235B1 are normally ordered removed without a review pursuant to the expedited removal process. But if they indicate an intention to apply for asylum or a fear of persecution in their country, then they're supposed to be referred for an asylum interview or a credible fear interview, which I'll be referring to as a CFI. So if an immigration officer conducts that interview and then finds a credible fear of persecution, then the non-citizen shall be detained for further consideration of the application for asylum. So when we see that shall in the INA, that indicates mandatory detention, shall be detained. And then placed into INA 240 full proceedings, so out of the expedited removal into the 240 proceedings. But unfortunately, we have the Supreme Court case from 2018, Jennings v. Rodriguez, which says that even when these in applicants for admission who are subject to expedited removal under 235B1, even when they pass the CFI and then they're transferred into full 240 proceedings, they're still going to be subject to mandatory detention. So what's important here is to highlight is that what it matters is that initial entry. If they are subject to mandatory detention based on their initial entry, that is what's going to remain throughout the case. And if we'll later see if they are re-detained at any point in time, they could still be detained pursuant to the expedited removal provisions. And this is an important thing to note because under the new ICE guidance and directive, it expands expedited removal and applies it specifically to certain people, certain parolees. And DHS is interpreting that 235B1 means that as long as someone is originally apprehended within 14 days, 100 air miles, and released or paroled, or if they're originally considered an arriving alien, they remain subject to expedited removal as their applicants for admission, no matter how long ago they actually entered the United States, and without regard to whether they were actually paroled into the United States after being released from detention. So even if they've now been here for years, they would still be subject to mandatory detention because what matters is that initial entry and what they were categorized as in that initial entry. So if someone is subject to mandatory detention under 235B, as Liz explained, they're not bond eligible. So you're going to see a lot of people in this situation who they've been released from custody after being granted parole by ICE, but not bond by the immigration judge. Because as we're going to discuss in a bit, an immigration judge does not have the authority to grant bond to people considered subject to 235B expedited removal or applicants for admission. So even even those who were put into expedited removal transferred to the 240 proceedings after passing a CFI, immigration judges still lack the ability to grant those people bond because they're still considered applicants for admission and they can only be released on parole. So let's take a look at that with a little scenario. So your client, Roberto, entered the United States 3 years ago, seeking admission at the port of entry in Laredo, Texas. He was placed into expedited removal proceedings. He expressed a fear of return. He was released on parole after passing a credible fear interview. His asylum application is still pending before the immigration court, and an individual hearing is scheduled in 2 years. 2 days ago, Roberto was detained by ICE during his check-in. So what do we think? Is Roberto going to be bond eligible? And you can go ahead and just answer that, put your thoughts in the chat, whether or not Roberto is going to be bond eligible. What do we think? We're getting mostly no's. Not under the current, yeah. Okay, right. So no, he's still considered an arriving alien, even though this was 3 years ago. So what matters is that initial entry manner, right? So he came to the border to a port of entry and is therefore an arriving alien subject to expedited removal and then mandatory detention. So when he's redetained years ago, he's still, years later, he's still subject to 235B mandatory detention. And so he's not going to be bond eligible because he wasn't the first time he was detained. So we could do a parole request, but ICE is probably going to be unlikely to release him because they already released him the first time on parole and decided they wanted to redetain him. Right now, there is some habeas litigation around redetaining arbitrarily, like they did to Roberto. There is an attorney in Virginia who's trying to build a class right now for those who are originally released on parole and then thereafter redetained in Virginia. So if they're detained in Virginia, if you know anyone in this category, he's seeking class members. So I'll put his email in the chat for you to contact him. And with that, I'm going to send it back to Liz.
Great, thanks, Corey. So now we're going to move on to kind of our second category of those subject to mandatory detention, and that's going to be detention under 236C. Okay, so this is the pre-removal order mandatory detention statute that is based on those who are inadmissible or deportable because of certain criminal grounds. Okay, so the language of the statute says the Attorney General shall take into custody any alien who is inadmissible or deportable under select criminal grounds of removability when they are released, usually from criminal custody. So again, when we see this word shall, it's a mandate. There's no discretion. These individuals will, under the law, be subject to mandatory detention. Okay. And again, they have to be inadmissible or removable, deportable under certain grounds. As many of you, of course, know, inadmissibility is found at INA 212 and deportability is found at 237. So it is really important to keep in mind that these mandatory detention laws can apply both to individuals who entered that inspection as well as to those who are here with lawful status, including very long time lawful permanent residents. Okay. The next part we want to focus on is that the non-citizen is supposed to be taken into immigration custody when they are released from criminal custody, right? So if they were arrested or convicted of a crime, like for example, in their state, they're supposed to go directly from criminal custody to immigration custody. So there has been sort of this dispute and litigation about whether ICE is basically, the argument was that ICE can only subject folks to mandatory detention if there is a direct transfer from criminal custody to immigration custody, and that if a lot of time has passed between those two portions of custody, then 236C should not apply. Unfortunately, while those arguments did have some success for a while, as a general rule, the Supreme Court has sort of knocked down that idea. So that what that means for a client is that a client can have a conviction from many years ago that falls into one of these select grounds for mandatory detention, which we'll talk about soon. And even if they've been out of criminal custody for many years, they are still likely to be subject to mandatory detention under 236C, assuming they meet the other requirements. And that was actually one of the other stories I found interesting in this John Oliver segment, was he highlighted a person who had a conviction for marijuana possession from the late 1990s. They were detained in 2010 and subject to mandatory detention for that marijuana conviction. So 14 years after the conviction that originally made him deportable, he was a very long time lawful permanent resident and a U.S. veteran. So you can see how broad these laws are, and they can sweep up people with very old and very minor criminal history. So that's something that we really want to be aware of, is this criminal, is a client's criminal history potentially going to subject them to mandatory detention? Okay, so let's dive a little bit more into 236C. So it can apply to non-citizens who are inadmissible under section 212A2. So again, that means folks who have not been admitted into the United States, people who are seeking admission as arriving aliens. They are going to be subject to the grounds of inadmissibility. This could also potentially apply in scenarios where a lawful permanent resident travels abroad and upon their return to the United States could be subject to 212, INA 212 because of a conviction that they may have, that they're going to be treated as an applicant for admission. So if you have a client who is inadmissible under 212A2 and they have been convicted of a crime involving moral turpitude, they may be subject to mandatory detention. Okay, there are a couple exceptions for this. The petty offense exception, many of you are familiar with from doing your inadmissibility analysis. If they have only one CIMT conviction, only one conviction for a crime involving moral turpitude, the maximum sentence is a year and the actual sentence is not more than 6 months, then they're not inadmissible. And similarly, they're not going to be subject to mandatory detention. There's also what we call a youthful offender or a minor offense exception if the person was under 18 when the crime was committed and they were released from confinement more than 5 years before the date of application or admission. Similarly, will not fall into mandatory detention provision. But anyone else who is inadmissible under 212A2 for a crime involving moral turpitude, they will be subject to mandatory detention. Okay. The other big one we want to flag here are drug offenses. You need to screen clients for any history with a controlled substance offense because that would put them squarely under the mandatory detention regime if they're inadmissible for a controlled substance conviction. And that includes conviction or admission of possessing 30 grams or less of marijuana, right? That makes them inadmissible and subject to mandatory detention. All right, so that's those who are inadmissible under 212A2. Let's take a look next at the next portion of 236C, which is non-citizens who are subject to deportability. And again, remember, this includes those who came on tourist visas, those who are refugees, those who are already lawful permanent residents. They have been admitted and subject to deportability under 230. They've been admitted and they therefore could be subject to deportability under 237 if they are deportable for certain offenses, and they can also subject them to mandatory detention. So a pretty wide range of crimes here that are going to subject these folks to mandatory detention, again, including if they're lawful permanent residents. So that includes if they have multiple convictions for crimes involving moral turpitude, if they've been convicted of an aggravated felony, that term is defined in the statute. Those tend to be sort of the most serious criminal category in terms of immigration consequences, which is going to trigger mandatory detention for those individuals. And there's a wide range of crimes that can be found in the statute. So you do have to analyze whether someone could fit into that category. If a person has been convicted of a controlled substance offense, there is an exception in under 237 for possession of marijuana of less than 30 grams. So they are not deportable and then thus not subject to mandatory detention. That's different from the inadmissibility analysis. So we want to make sure to flag that as well. Other crimes that can subject them to mandatory detention: firearms-related offenses, crimes related to espionage, and then finally, if they have even just one crime involving moral turpitude committed within 5 years of the date of admission, and they are sentenced to a year or more in prison, that may subject them to mandatory detention. Okay, so again, pretty long list of crimes or grounds of deportability that can subject even your lawful permanent resident clients to mandatory detention under the statute. And then finally, to make things even more complicated for us under 236C, Congress just this year amended 236C to add in the Laken-Riley Act, which expands the group of individuals who are subject to mandatory detention under the statute, okay? And so, as many of you know, this law is named after a student from Georgia who was tragically murdered by an asylum applicant from Venezuela. And the way the law was enacted was essentially kind of fitting the facts of the case. So he had been apprehended for petty theft in New York, but had not been detained. And so the way the law, again, is written is sort of mandating the detention of people like the person who was ultimately convicted of murdering this young woman. So it expands the crimes leading to mandatory detention by adding this 236 C1E IE rather, and the non-citizens subject to mandatory detention under Lake and Riley Act. So it only applies to people who are inadmissible, right? So they are inadmissible for having entered without inspection, for having committed fraud or misrepresentation, or for a lack of valid entry document. And for those who are charged with, arrested for, convicted of, or admit having committed any of these listed crimes on the slide. So burglary, theft or larceny, shoplifting, assault of a law enforcement officer, and any crime that results in death or serious bodily injury to another person, okay? So it is kind of interesting the way this law is written, that it references specific crimes rather than referencing generic terms like aggravated felony or crime involving moral turpitude, as we see in other parts of 236C. And it's really crucial here. This does not require a conviction, right? So unlike with the deportability grounds that do require a conviction, again, this can be applied against folks who are charged with, arrested for, and convicted of. So it's much broader in that sense. So let's take a look at which non-citizens the Lake and Riley Act will impact, and then some areas which are a little bit more sort of unclear and maybe where we can make some arguments that it should not apply. So if we can go on to the next slide, the non-citizens that are impacted by Lake and Riley Act, are those who are pending a decision in 240 proceedings. So there is an argument here that it actually only applies to individuals who are already in Section 240 proceedings. As I mentioned, it applies to those who entered without inspection, without valid entry documents, or those inadmissible for immigration fraud. It can potentially be used against individuals who have pending claims or even who have been granted deferred action for childhood arrivals, DACA, or another type of deferred action status, right? Because those immigration protections don't confer an admission, right? The person hasn't necessarily been admitted to the United States. And so this very broad law could potentially impact them. Lake and Riley Act does not apply to lawful permanent residents, people granted refugee status, and those who entered on non-immigrant visas. Why? Again, it only applies to individuals who are inadmissible under certain grounds. There are also arguments that we can make, although it's not really clear. I'm not aware of how much this has actually been litigated yet, about whether or not the law should apply retroactively to arrests that happened before its effective date of, I believe, January 29th, 2025. So you can certainly make the argument if you had someone who had an older, say, arrest for a theft-related offense that was resolved prior to the effective date of the law, that Lake and Riley Act does not apply to them. And there's also an argument based on the language of the statute that if the charge is completely dismissed, that it does not apply to them, right? Because the language talks about is charged with, is arrested for, is convicted of. And so if this happened in the past and the charge was dismissed, it doesn't apply to them. Again, this is all very sort of unclear at this point because the law is so new, but definitely something to keep in mind in terms of the arguments that you can make against this law being applied to your client. Okay, so I know that was a lot of information. Let's work through some hypos together so we can see how this may work kind of in action. So we have a few examples, and I think we have some polls here, I believe. I don't see them. I don't know. Corey, do you see the polls? Are you able to pull them up?
No, I don't.
Okay, we can just do. Okay, we can just do the. Okay, I see them. Thank you. Thank you, Danny. Okay, let's start with our first one. So we have Matt, who is 25 years old, was convicted of one crime involving moral turpitude relating to fraud last year. Matt entered without inspection in 2005. The maximum possible sentence for this crime is 18 months, and his actual sentence was 4 months. So what do we think about Matt? Is Matt going to be subject to mandatory detention? What do folks think about this? Let's think about Matt. Okay, just going to give it a little bit of time, maybe 10 more seconds and let people vote. Okay, looks like most people have voted. And looks like most of you, 70% of you said yes, and I agree, right? Okay, so he entered without inspection, so he's subject to inadmissibility, right? And the question is, as we know, if he is admissible under 212A2, he's going to be subject to mandatory detention unless he falls into the petty offense exception, which he doesn't, right? Because the maximum possible sentence here was 18 months. And there's no minor or youthful offender exception because he was over 20, it was like 24 years old when this happened. So exactly right. I think that we put in the facts, this is a CIMT, you know, sometimes you could make an argument that it's not, but under these facts, yes, he would be. Okay, next example, we have Anna, age 30, who was convicted of a CIMT related to theft 3 years ago. She entered without inspection in 2012. Her maximum sentence possible is 12 months, and the actual sentence is 4 months. What do we think about Anna? Is she subject to mandatory detention? Yes, no, or maybe? Okay, give it a few more seconds. Okay, looks like most people have voted. Okay, most of you are saying either yes or maybe, and I tend to agree with you. Okay, I think I'm more in the maybe camp, but let's go through this. Okay, so she's entered without inspection, so she's subject to INA 212. She's been convicted of a crime involving moral turpitude. It is a petty offense, right? So she qualifies for the petty offense exception. She's not subject to mandatory detention under 236C1A. Okay. That's sort of how we've actually used this example for a while in our trainings, and the answer was always no, she's not subject to mandatory detention. However, that has changed, right? With Lake and Riley Act, she may be subject to mandatory detention. She was convicted of a theft-related offense, right? So I would guess DHS may argue she's subject to mandatory detention. The reason I say maybe is we can make some arguments, right? We may be able to say this is not retroactive to her because this happened several years ago before the law was enacted. So we can argue that it shouldn't apply retroactively to her. But this is an area that's really kind of new and we would need to test that, right? And then, as I mentioned, there's then other argument we can make. We don't know if she's in proceedings, but we can also make the argument she's not in proceedings. Maybe it shouldn't apply, but it's going to be tricky because they'll probably just put her in proceedings. So not sure how far that will get us, but certainly the retroactivity argument, I think, will be a strong one that we can raise. Okay, final example here. So we have James, who is a lawful permanent resident. He was convicted of 1 count of felony theft in Virginia 2 years ago, and last year he was convicted of marijuana possession in South Carolina. Is James subject to mandatory detention? And you can say yes, no, maybe. Give you guys a few more seconds to vote. Okay. All right, again, we have kind of a split decision here. Most of you, almost half of you are saying yes, he is. And then the remainers are split between the no's and the maybes. I think we just need more information. So I guess that was kind of a trick question. I didn't really give you enough information to make this determination. He is a lawful permanent resident, right? He's subject, would be deportable potentially under 237. We need more information on the felony theft, right? Well, first of all, we need to figure out, is this going to be a crime involving moral turpitude? We don't know what his sentence was, right? And so if he was sentenced to a year or more, potentially he's deportable for it being an aggravated felony. If it's not an aggravated felony, let's say he got a sentence of less than a year, then I don't actually think that he's going to be deportable on that offense at all. So really this kind of turns on what his actual sentence was for this crime, okay? The marijuana is going to subject him to mandatory detention only if it's more than 30 grams of marijuana. Otherwise, he's going to fall into that exception. And what about Lake and Riley? Does it apply here? No, right? He's a lawful permanent resident, so he's not going to be inadmissible under 212A6, A7, or A6C1. Okay. So this one again is a maybe. We just need more information about what his sentence was and how much marijuana was involved in this conviction to determine whether or not he's going to be subject to mandatory detention. Okay, so let's say that DHS has detained our client under 236C, and we want to make an argument that they're not actually subject to mandatory detention. How do we do that? And maybe Becca can talk to us about matter of Joseph hearings.
Maybe is a good qualifier. So if DHS is alleging that you're subject or your client is subject to 236C, the only option for release is, well, I guess there's one option. It's a matter of Joseph hearing, and that's where you're requesting an immigration judge to review whether or not DHS has properly applied 236C to your client's case. And the way that you do that is by filing a request for a matter of Joseph hearing, which is called a Joseph hearing because of matter of Joseph, which is 22 INN 799, BIA 1999. So that's the case that gives our clients the ability to seek or to argue that 236C is not being properly applied. And matter of Joseph also applies to non-LPRs, and that's from matter of Cotlier, which is a BIA case from 2007, because originally the original matter of Joseph pertained to an LPR, and it was unclear for a while whether non-LPRs could seek IJ review of mandatory detention, and luckily they can. So what you're doing in a matter of Joseph hearing is trying to demonstrate to the judge that DHS has improperly applied one of those mandatory detention grounds, like perhaps they've improperly concluded that a particular crime is a CIMT, for example. So it requires an analysis of what the government is saying about your client's mandatory detention. And so that's I guess in a nutshell, what matter of Joseph hearings are. And practically speaking, if you're going to enter into this sort of representation, I often suggest limiting the scope of your representation to bond or custody only, right? So when you're filing an E28 with the court, and probably you all already know this, but just to be clear, you can file like for full representation, meaning the entire case, merits, and custody, or you can limit the scope just to the bond or custody matter, which is what I would recommend if you're going to be pursuing a Joseph hearing. And you should be prepared during the Joseph hearing to not only demonstrate that DHS was incorrect when they applied 236C, but that if the judge agrees with you that your client is also eligible for a bond. So you kind of want to lay out just basic bond eligibility as well, which we'll get to in a minute. And so at the hearing, the judge will hopefully arrive at the conclusion that you're correct and your client was improperly subjected to 236C, and then should be able to file for a custody redetermination hearing. So that's Joseph hearings in a nutshell. Unfortunately, I think it's very important if you're taking a sort of representation, just to be prepared to, when you are consulting with a client and looking at a case, not to just assume that DHS is correct in their assessment that your client is subject to 236C.
Thank you. That's such a great point. Okay, we're going to move on now, I think, to our final kind of mandatory detention bucket before we get to the good stuff, which is how can we actually get our clients out, right? So the final category we want to talk about is the post-removal order detention, right? So if you have a client who has a removal order already, they are subject to 241A2 which is the post-removal order detention statute. As I mentioned earlier, detention is going to be mandatory during the first 90 days after the removal order, and then discretionary after that 90-day period. But even after that, the IJ does not have jurisdiction to grant a bond or release. That's going to be up to ICE to determine whether that person should be released. And this statute does apply to individuals who are in withholding only proceedings. So basically those who were issued removal orders, departed, entered the US without inspection, and then passed a reasonable fear interview. So they're in withholding only proceedings. And that there's a Supreme Court case on the slide here, a citation that talks about how those folks are going to be subject to this statute and mandatory detention. There are kind of interestingly more restrictions placed on the length of post-removal order detention. So there's a case from 2001, which really placed a lot of limitations on post-removal order detention. This is an older case, and it's from when the Supreme Court was different than it is now. I think it's kind of worsened in terms of friendliness to immigrants since 2001. But in this case called Dividus v. Davis, the court ruled that immigration authorities cannot indefinitely detain individuals ordered deported, and their detention has to be tied to the possibility of eventual removal. And they set this 6 months as kind of the appropriate period. So after the 6 months period, if they've been detained post-removal order and they can't be removed, then the government kind of bears this burden of showing, kind of rebutting this presumption that there's no significant likelihood of removal in the foreseeable future. So then the burden really becomes on the government to justify their continued detention if they can't be removed from the United States. Okay, and I don't know. I mean, it's kind of interesting now, sort of thinking about this administration's willingness to send people to third countries in a way that I think is new. And we've of course seen this news this week about the horrible conditions for Venezuelans who were shipped off to El Salvador. So that is something that we need to be sort of cautious of, is that they are becoming much more aggressive about not necessarily removing the person to their home country, but rather to a third country altogether. Okay, so we have one example just to take a look at. We have Jason, who is in withholding only proceedings. He received an expedited removal order in 2022, departed the US, and then re-entered without inspection. He passed a reasonable fear interview, and his hearing on his withholding only application is scheduled for May 1st, 2025. So what do we think? We're just going to use the chat for this. Do we think Jason is eligible for bond from the immigration judge while he's awaiting his withholding only proceeding or hearing? What do folks think about this? If you can just go ahead and put it in the chat. Most of you are saying no, and I agree with the no's, right? So this is the Supreme Court decision, the Guzman Chavez case that you saw cited on the prior slide. No, he's not going to be bond eligible. Okay, he's subject to the 241A2, the post-removal order detention statute. Let's say he's granted withholding at his hearing. Is he going to be bond eligible then from the immigration judge? What do we think about this? Can the IJ in this scenario grant him bond? What do folks think? Folks are saying yes. I wish it was yes. I don't think it is, right? At this point, the IJ still does not have jurisdiction to grant him a bond. You'll be more likely to get released from ICE. But even then, it is often the case that ICE will keep withholding recipients detained for several more months as they try to effectuate removal to a third country. So certainly you should ask for a custody review by ICE after they've been detained for 6 months or more, or you may involve having to go to federal court. But unfortunately, the IJ still doesn't have jurisdiction over the bond in that situation. Okay, let's now move on to talking about release on parole.
Okay, so as we briefly mentioned earlier, ICE can release people on parole, even if they are subject to mandatory detention. So ICE can really release any applicant for admission on parole. So if they entered without inspection, if they came as an arriving alien seeking asylum, anyone who has not yet been admitted can be released under this provision, INA 212 D5 parole. As we know, the arriving aliens who arrived and then were detained and then put in expedited removal and then 240 proceedings, they can actually only be released on parole. There's also something called conditional parole that we're going to take a look at a bit in a moment, which IJs can grant as well. But let's first take a look at 212 D5 parole. Again, it's for anyone who has not been admitted into the United States. And so they're considered applicants for admission. And again, those arriving aliens who were placed in expedited proceedings past the CFI and then put into the 240 proceedings under Jennings can only be released on parole. Those who have passed the CFI under this ICE directive 11002.1, it actually tells ICE that they should be released on parole under 212 D5 parole. So if someone passes a CFI under this directive as it is now, and provided it's not rescinded, they should be released on parole. So let's take a look at who has the authority to grant 212 D5 parole. So ICE, USCIS, and CBP, which we know are all sub-agencies of DHS, they all divided up the authority over adjudicating parole requests under humanitarian parole. But for people in ICE detention, which is the focus of today's presentation, only ICE can grant parole to them under 212 D5. So unfortunately, IJs have no jurisdiction to either grant these parole requests or review ICE parole decisions if ICE does deny a parole request. And so conditional parole is another provision. It's under 236A2B. It's available to anyone who is detained and in 240 proceedings, except, of course, those arriving aliens subject to mandatory detention. And it's simply considered a release from detention pending the outcome of proceedings. So those who entered the U.S. after being granted parole abroad or with a grant of parole at the border, who came and are targeted, for expedited removal as arriving aliens, they would not be subject, they would not be eligible for this conditional parole. But IJs can grant this. So this is what's so beneficial about conditional parole. In order to request this parole or in order to be granted this parole, you have to prove the client or the requester does not pose a danger to property or persons, and they're likely to show up to future proceedings. This request for conditional parole can be made with a request for humanitarian parole to ICE when you make those requests to ICE, which we'll look at in a moment, or it can be made during bond proceedings before an immigration judge. So ICE, as we know, can grant conditional parole. They're not as familiar with it. It's less likely that they will grant it. IJs have the authority to grant it, but they rarely do. A request can be made, as I said, with the parole request or directly to the IJ in the bond memo, which Becca is going to be looking at in a moment, in the bond motion submitted to the IJ to be considered with the request for bond. Okay, so we're going to take a look at a few examples. So we have Francis. He attended a CBP1 appointment in November of 2023, and then he was paroled into the United States. He was issued an NTA, but he was never given a CFI. He's arrested by ICE at his ICE check-in. So is he going to be eligible for humanitarian parole? And what about conditional parole? So let's take a look. What do we think? Whether or not he's eligible for humanitarian parole. So DHS, as we discussed earlier, they deem him as an arriving alien even after he was paroled in the United States. He's going to remain an arriving alien. So he's going to be placed into expedited removal because he wasn't given that CFI and placed into 240 proceedings. So he's going to be subject to mandatory detention, and he's only eligible for release under humanitarian parole. So no bond and no conditional parole. Now, what about Florinda? So she entered the United States without inspection in January of 2013. While driving to a doctor appointment in Texas, she was stopped by CBP and detained. So she entered without inspection years ago. Is she going to be eligible for parole? So she's not. She's not subject to mandatory detention. She's not subject to expedited removal as an arriving alien. She is likely detained under 236, just general detention authority, as she was arrested in the interior years and years after she entered. So she's going to be eligible for both humanitarian parole as well as conditional parole and bond from ICE or the IJ. And then last we have Ferdinand. So he entered the United States in without inspection in 2022. He was apprehended the day he entered. He was then detained, given a CFI, and then he passed it, but they kept him in detention pending full 240 proceedings. So as we looked at this earlier, he's in 235 mandatory detention under that Jennings Supreme Court case. So this, subjects him to mandatory detention, and he's only going to be eligible for humanitarian parole. So not the conditional parole, and then not bond. Okay, so let's take a look at how we can do these parole requests. So the parole requests for people who are in mandatory detention and can be released on humanitarian parole are going to be submitted directly to ICE. So ICE makes the parole determination on these types of parole requests on a case-by-case basis for humanitarian reasons or significant public benefit. So you, in the request, really have to argue which one this falls into or both, and then why. So they usually interpret significant public benefit to people who are kind of like for use in like law enforcement or court proceedings, or in the interest of national or domestic policy. So these are going to be less frequent that you see or that your case is going to fall into this. But then it also provides situations where ICE should consider releasing people for humanitarian reasons. So those are going to include whether when someone's who's detained is suffering from a serious medical condition, or they're pregnant, or they're a minor. So things like that, maybe like family issues for family members who are not detained, medical reasons. So it's going to be more of those types of scenarios that and arguments you're going to argue for the humanitarian reasons. Okay. So they also need to prove their identity and that they're not a flight risk and they're not a security risk. So what does flight risk mean? And what can you provide to show they're not a flight risk? So it means that you're going to continue to appear for your court hearing. So if ICE decides to release you on humanitarian parole, you're going to show up for your hearings, you're not going to disappear. And so evidence you can provide to show that you're going to continue to come to court and you're not going to run away and hide is because you have these family or community ties. You have a lot of children. You have a long employment history. You've worked at the same job for years. You own property in the United States. You own a house. And another thing you can provide evidence of is eligibility for immigration relief. So if you have this solid case for adjustment of status, for example, through your spouse, that was going to mean it's more likely that you're going to show up for court because you know that it's not as likely you'll be ordered removed because you have this eligibility for release. And then in terms of security risks, you have to kind of prove why you're not a risk to the community. So evidence can include, the lack of a criminal record, affidavits from people, mental health evaluations, things of that nature to prove that you're not going to be a security risk if ICE does release you. So how to submit a parole request? They're submitted again directly to ICE ERO. No E28 is required to do this. You don't need to submit an E28 to the court. You just complete a G28 submitted to ICE. It doesn't need to be submitted to OPLA. There's generally a ICE ERO email address depending on the detention center, and you just submit the G28 to that email, or you find your client's deportation officer and submit it to them directly, but generally they want you to send it to the email address. And then for detained clients, ICE should accept G28s that are not signed by the client. You can just put detained in the signature line. And again, you don't need to serve anything to OPLA. You just need to submit the G28 directly to ICE. You just need to submit as evidence, again, evidence in support of not a flight risk, not a security risk, and as well as proof of the client's identity. So a passport, birth certificate, something to prove identity. You also want to submit a letter of support from a sponsor, which includes that they're going to make sure they come to their hearing. They are going to provide financial support if necessary. And then, so that will also entail providing proof of that sponsor's income. And then that sponsor's immigration status as well. So if they're a permanent resident, you're going to want to submit a copy of their green card. And then again, any evidence you can in support of the request. So letters, from children, letters from spouses, that employment information, property, community ties, all of that you're going to want to wrap up in one package and then submit that to the deportation officer. So what happens next? So once you have submitted that request, technically the deportation officer has 7 days to submit a written decision on the request. It doesn't generally happen in 7 days, so there's going to be a lot of follow-up that might be required in order to get that decision on the parole request. If they grant it, great. They can be released on 212D5 parole. If not, there's limited things you can do. Again, when these people are subject to mandatory detention, there is the option for a parole redetermination request. I'm not going to spend a lot of time on this because if the deportation officer denies parole, it's highly unlikely that this is going to work. These were effective during COVID, especially because every single person was kind of in, suffering from medical issues and like this threat of like this impending medical condition because of them being continued to be detained. But these are not going to be as likely to be successful now, but it's basically just, trying to identify any errors in the deportation officer's denial and then submitting them to the field office director with jurisdiction over where your client is detained, asking basically that they reconsider their denial of the parole. Okay, and with that, we're going to turn it back to Becca to discuss bond.
Hi there. Okay, great. So in my mind, like this is where you want your detained client to be. I mean, you don't want them detained, but they're there. Ideally, they are eligible for bond. And just first, like some basic principles, start out by thinking of it this way. When your client is not subject to mandatory detention and they're eligible for a bond, meaning that the IJ does have jurisdiction over custody redetermination, the two major scenarios you're going to see this in are people who are encountered at the border as they're attempting to enter the United States, or they were picked up somewhere in the interior during some ICE enforcement encounter, be it at a county jail or be it in a raid or some other encounter with ICE. ICE or DHS is making that initial custody determination saying it's discretionary, but in our discretion, we're going to detain this individual. They could also set a bond at the outset. They could set a bond for $10,000, and you can still file for a custody redetermination to get that bond lower. That's pretty rare. Typically, ICE is either, if somebody is not subject to mandatory detention, in ICE's opinion, they're either going to decide to detain that individual or release them on their own recognizance pending 240 proceedings. So once you've established that your client is eligible for a bond, and again, I have a couple of notes I was gonna make sure I mentioned about that. And to just sort of make that assessment, you know, we've already gone through this with Elizabeth and Corey, but you've established that the IJ has jurisdiction, meaning your client isn't an arriving alien or otherwise not eligible for an immigration judge to make that determination. They're not subject to mandatory detention, okay? Then you're assessing what you have to establish for the judge, right? You want to establish your client isn't a danger to the community or a threat to national security, that they're not a flight risk, okay? And so I'm also looking at the slides as I'm going through this. So those are the main factors that you need to demonstrate at a bond hearing. And I'll also mention at this juncture too, it's important, and I kind of was discussing this earlier, custody redetermination hearings, which is just, that's the term for bond hearing. Those two things are used interchangeably. These are separate and apart from removal proceedings, and that's BIA case law. So it's a separate record of proceedings. And you also, as I mentioned earlier, you have a decision to make at the outset of your representation, whether to limit the scope of your representation to just bond or custody or full representation. And that's obviously a case-by-case basis, depending on the amount of work you're hoping to take on. So with detained clients, of course, they want to, most of them want to get out of the detention center as soon as possible. That's understandable. I mean, to go back to the beginning of this program, looking at the John Oliver clip, these places are terrible places to be. Although these individuals are being detained subject to immigration violations, the conditions of confinement are similar to prisons where individuals are incarcerated for criminal activity. And it's a terrible place to be. So you want to move quickly, but you also want to make sure that when you file your motion for custody redetermination, you have all of your evidence ready to file contemporaneously with the bond motion, because sometimes the bond hearing will be set pretty quickly. And so you can always supplement if you feel like once you file your motion and evidence and then the court schedules your hearing, you can typically file additional evidence if you want, or if there's things that you were waiting to receive. But my advice is to make sure you have just about everything to prove those essential elements around flight risk and danger to community. So some of the things mentioned in this slide are a support letter from a sponsor. And a sponsor in this case is referring to someone where your client can say, essentially establish, hey, if I'm released from detention, this is where I'm going to live. Ideally, and essentially, the sponsor should be someone with some form of immigration status for obvious reasons, right? First, you don't want to put at risk somebody without status submitting a bunch of evidence to the court. Second, if you want to argue that someone's not a flight risk, it's nice if they have ties to someone who has some form of status in the United States, whether that person's a permanent resident, US citizen, has TPS or some other form of valid immigration status. And more IJs over the years want to see financial ability to support themselves. I've always thought this was sort of a ridiculous requirement, but it probably goes to flight risk, right? Like this individual, it has a sponsor, like a lot of judges want to see the sponsors like proof of income, so that the sponsor is going to say, yes, I'm going to house this person. I'm going to drive them to and from their immigration court hearings and check-ins, and take care of this individual until they apply for and get employment authorization. Good character evidence is always great. Any declarations from individuals who know your client that can speak to their good moral character. Eligibility for relief. This is an important factor because in theory, you shouldn't have to litigate your client's entire case, right, at a bond hearing, because they're separate from the removal case. But in practice, you do want to at least show some core elements of eligibility. Like, let's say your client plans to seek asylum in the United States. Just establishing something as basic as, this is the particular social group my client belongs to that they plan to argue their asylum case around. Or if somebody's eligible for non-LPR cancellation of removal, you want to establish something like the 10 years physical presence required for that relief, maybe get into hardship to an extent. How much you have to submit is also going to be balanced on the facts of your case. If your client has no criminal history in the United States or elsewhere, and they can establish just some very basic prima facie argument for relief or removal, then they're in a better position than somebody who has multiple DWIs or someone who has, you know, been through the criminal justice system, in which case you're going to want to mitigate that with additional evidence of good moral character or other considerations, such as, or they have a young child that they care for, or other mitigating evidence that you can show to kind of balance out any negative factors in your client's case. So the way that this works just procedurally is, you would file your E-28, which you can do online, and you then file your motion and your packet for custody redetermination at the same time. If the court accepts the motion, and that's a big if, then they will do one of two things: to schedule the hearing, or often the clerk will reach out to you directly to see if you're available for a hearing. And with a bond hearing, most of the time you'll get a decision at the hearing. Right then and there, the judge will either grant or deny bond, or, and this is a big or, and it's important to flag that if the judge feels like something is missing, they will often signal to you that you can withdraw your motion, okay, right there at the hearing, and there'll be no outcome. And that's very, very important, because with bond hearings, you should think of it as if you get one chance, right? If the judge denies bond, you can certainly appeal it. Your client will remain detained during the pending appeal, but you can't get a second bite at that apple unless there are changed circumstances, which are pretty difficult to demonstrate. And then finally, a judge could reserve their opinion. They could wait and weigh the evidence, and I've had that happen as well, and they won't issue a decision that day. I don't know if you all need me to pause so you can move on, or if I should keep waxing.
Keep going. I'm getting some good questions. I don't know, can I maybe throw you a couple questions we got?
Sure, yeah.
Related
Yeah.
to this? Like, someone actually, I thought this was a really interesting comment.
Yeah.
Someone said that their client had a long history of employment. Without authorization, they were deemed a flight risk and denied bond because the IJ determined they would likely work again without authorization. I thought that was kind of crazy. I was wondering what your thoughts were.
I mean, that is crazy, right? And you never know with an IJ, because to me, employment history for somebody who's been in the US, even if it's without authorization, I always submit that, because it establishes ties to the community, the fact that they can financially support themselves and thus afford an attorney, which, if you can establish that you have an attorney to represent you moving forward, that's another factor to consider, I think, and many judges agree, as far as flight risk goes, right? But what can I say? These immigration judges have a lot of power, and I mean, even just today, I'm working on a motion for a bond hearing would be this individual's second bond hearing, because they were denied the first time. And the reason why they were denied the first time, which was back in July of 2024, was they had 3 arrests for shoplifting. Now, this is pre-Laken Riley, okay? So these are misdemeanor shoplifting charges, none of which subjected them to 236C. And the judge just thought that this shoplifting, you know, at the Ralph Lauren Polo store really made them a threat to the community. Very dangerous, horrible crime. I actually wasn't the attorney on that bond hearing. Another excellent pro bono attorney handled that case. I then took over the case for the merits. My client was pursuing asylum based on their status as an LGBTQ person from Jamaica, which is a pretty strong claim considering sex between men is criminalized in Jamaica. So at any rate, long story short, he was granted asylum on the detained docket. Since he was denied bond, he had to sit and wait to go through the whole process of a detained merits case. He was granted asylum, yet the government appealed. He remains detained. So now I'm filing a new bond motion based on changed circumstances, arguing that the grant of asylum is a changed circumstance, right? So what I'm interested to see, and there were some questions earlier, is will DHS try to argue that now actually this individual is 236C because Lake and Riley Act, right? And that goes back to this unanswered question of, is it retroactive? Obviously, I'm not going to even bring it up in my motion, and I'm prepared to argue that it shouldn't be retroactive if they argue that it should be. But you know, immigration judges have a large amount of discretion when it comes to these things. So I tend to think the more evidence you can submit about any sort of positive factor around your client's case, the better. I live in Charlotte, and most of my clients are detained about 7 hours from here at Stewart Detention Center. To the extent possible, I go in person, and I work at a nonprofit. We don't charge any fees for representation, but I try to go in person when I can, because I also believe in-person representation is impactful to the judge and, to more importantly, to the client. But practically speaking, attorneys that understandably charge fees for services, a client doesn't want to also, in addition to everything else, pay for travel. So at Stewart Detention Center and most detention centers, they will allow a WebEx appearance for a bond hearing. And there's nothing wrong with that. I'm not somebody who believes you shouldn't take on this representation if you can't be there in person. I think that excellent representation, even via WebEx, is better than no representation. So just know that if you work at a nonprofit or you're considering doing this work pro bono, considering like the incredibly problematic times during which we're living, you don't have to commit to going in person. You can do it via WebEx. If you have the ability or the resources to go in person to a detention center and represent your client, I highly recommend it. It's extremely rewarding. And I know for me, if it was my physical liberty being restrained, I would love to have an attorney sitting at a table with me. And bond hearings probably take the longest, but well, the average bond hearing is 5-10 minutes. This isn't like a merits hearing. If you do representation in individual hearings before EOIR, this is not as involved. I've had bond hearings that have lasted longer, perhaps because of a very complicating issue or because I want a witness to testify. But probably the longest bond hearing I've had has been 30-40 minutes. So it's not a huge time commitment. You just have to, like anything else, look at the whole picture and your client's full situation and see what you think you can show this judge to convince them that and that, to me, great things to do are if they're individuals who can come to court to support your client, if they have a U.S. citizen or LPR partner that can come, or a child that can come, community members, if they are members of a house of worship of some kind who want to come and support them, even on WebEx, even just logging into WebEx and being a part of that hearing, I think shows the judge that this is a human being who might deserve a chance to get out of detention.
Thank you for that, Becca. That's really great tips. Okay, I think we're going to move on on, just because we're running a little short on time, to habeas. We have two more kind of topics: habeas petitions and stays of removal. Would love to get your thoughts potentially on both of those as well. But I just wanted to spend a couple minutes talking about habeas petitions. So this is kind of it's a type of court order that is in our Constitution and statutes, and it can be used in immigration cases. And basically, what you're doing is challenging whether the person's detention or imprisonment is lawful. So you can file these in federal district court where the non-citizen is detained, and the petition has to allege some way in which the detention is unlawful. So on the next slide, we'll see some examples of this. I mean, unfortunately, we have lots of kind of current examples just from the news. For example, I'm sure many of you have seen the story of Mahmoud Khalid. He is a lawful permanent resident who was arrested and detained recently. He's a Columbia student, and he was sort of advocate for pro-Palestinian causes, and he was sort of arrested for reasons that seem to be somewhat mysterious as to why he's being held. And so essentially the point here is that his detention, his lawyers are challenging his detention via a habeas petition, right? So they're arguing that his arrest and detention is on the basis of his speech and activism, which violates the First Amendment and the Due Process Clause. So you'll often see habeas petitions that are filed on constitutional grounds, right? So if the detention of your client is prolonged, right? If it's lasting an excessive period of time, particularly in cases where it's a post-removal order detention, if the conditions are detention are such that they are a violation of due process. We saw some of those filed during the COVID-19 pandemic. So those are some examples of sort of constitutional violations. Sometimes you'll also see habeas petitions filed when the detention is unlawful because it's not authorized by statute, regulations, or agency policy. So an example of this, unfortunately, we've heard stories and seen reports of TPS holders being detained, and that is actually unlawful under the statute, under INA 244 D4. Their TPS would have to be terminated first before they could actually be detained. So there have been several habeas cases filed challenging that detention. There's a couple other examples on this slide about challenging this policy under the first Trump administration of categorically denying parole. And then, as we've been talking about, arguing that your client does not actually fit into these mandatory detention provisions because their offense is not a crime involving moral turpitude or an aggravated felony. And of course, you can do that via your matter of Joseph hearing, but if you don't have success with that and you think you have a strong argument for why your client is not in the mandatory detention provisions, then a habeas petition is probably the way to go. Becca, I don't know if you have anything else you want to add on habeas petitions from your work with pro bono attorneys, or
Yeah, no, I would just say, for me, my habeas practice was limited to a totally different type of habeas petitions, which were for individuals who were held on ICE detainers longer than 48 hours back in the day. And so in the context of prolonged detention, I work with some excellent nonprofit groups that will step in if you feel like your client. So I think it's something everybody needs to be aware of as an option, and reach out to folks. Like, for example, because I'm in North Carolina and my clients are typically detained in Georgia, there are groups there that will step in and do habeas petitions if they agree that your client is subject, or is it, if that would be appropriate relief for them to challenge their detention. So I don't do federal habeas petitions, but for sure you have to be aware of it and ready to reach out. And especially if you're in the nonprofit sector, usually there's somebody willing to assist. If you're in private practice, then you should definitely make it a part of your toolbox and know who you can refer out to if you can't do it yourself.
Yeah, that's great. Thank you. Okay, I think we're going to transition to our final topic, which are stays of removal. And I'm going to turn it to Corey to talk to us about automatic stays.
Thanks, Liz. Okay, so there's certain situations where when a removal order is issued, they're going to be automatically stayed. So they're not going to be affected. The person's not going to be removed based on that removal order. And it's in these circumstances here on the slide. We're not going to go into all of them, but obviously within that 30-day appeal period, if DHS reserved appeal or you a reserved appeal, it's not going to be affected during that time. So that removal order is going to be automatically stayed. If the direct appeal is filed, it's going to be stayed pending the outcome of the appeal. There's certain motions to reopen, like if you submit a motion to reopen an in absentia order, or a motion to reopen filed by battered spouses, children, parents, for the purposes of applying for a VAWA adjustment or VAWA cancellation or removal, that's going to automatically stay those removal orders as well as certain federal court remands. So these are situations where you don't need to file a stay. And when I'm talking about stay, what do I mean? So a stay can be filed directly with ICE via Form I-246, where it's not automatic, in order to basically prevent them from, removing the person while we're waiting for something else going on, maybe some pending affirmative relief to be adjudicated. So you should consider filing this stay. Probably not where the person is not detained in this enforcement climate. So you want to closely consider this decision whether or not you file. You don't want to put someone on ERO's enforcement radar where they're not there already. So you probably want to do this in the context of someone who's already detained. There's direct guidance for ICE where someone has a pending U. It's updated 2019 guidance that basically tells ICE they don't really need to consider the merits of the U petition like they used to have to go through the application and all the evidence and see, and then request a bona fide decision from USCIS. So they'd have to remain detained during all this where someone was detained and then they couldn't approve the stay of removal before they got this bona fide decision. So if you do have, in these limited circumstances, someone who is detained with this pending U, or even someone who is detained with some outside pending collateral relief that you're waiting to be adjudicated, that's probably going to be the context where you file the stay for someone who has this outstanding removal order that you don't want them to effect yet. So the required evidence is here on the screen. You submit it with the 246. There is a filing fee of $155. It's going to include a lot of the same information you'd submit, with a parole request or a bond request. And they're there on the screen. And then I'm going to turn it back to Liz to discuss stays of removal with the BIA.
Yeah, so I'm just going to talk about kind of the BIA and federal courts together. The situations where the BIA would entertain a stay request are pretty limited. So it's basically if there's an appeal from an IJ's denial of a motion to reopen, or there is a motion to reopen or reconsider a prior BIA decision that is pending. Okay, so again, like as Corey said, if it's a directed appeal, then that's an automatic stay, so you don't have to file a stay in that situation. The standard for a stay comes from this Supreme Court decision, this case called Ken, I guess it's pronounced. So where the applicant has made a strong showing of success on the merits, applicant will be irreparably harmed, injured if there's no stay. And then they would weigh that against whether that will injure the other party in the proceedings and where the public interest lies. And so basically they're basically weighing kind of the applicant's interest against the government's interest. And when you're looking at federal court stay, which we can look at the next slide, they use the same standard. Okay, so got the standard from this Incan decision, and they weigh those 4 factors. There is no automatic stay of removal when a petition for review is filed. So keep that in mind, that you do need to separately file a motion for a stay of removal if your client has filed a petition for review in the circuit courts. And the circuits do vary. So some courts issue a temporary stay while the motion for a stay is being considered. but others don't, right? So in many circuits, the DHS can actually remove that person unless the court grants a stay motion. So if you are in one of those circuits, you should ask for the motion for a stay to be considered on an emergency basis. So I guess I could give one example. I have a client who recently filed a petition for review in the Fourth Circuit. We're working with a group of pro bono attorneys from a law firm on this, and they were successful in getting a stay for my client in the Fourth Circuit based on the likelihood of success on the merits, right? So they were arguing that the board made several serious errors when considering the case, showing that she'll be irreparably harmed because she's an asylum seeker who would face harm in her home country, and then showing that the public interest did not favor her removal. There's no public interest in having her, an asylum seeker with no criminal record, removed from the United States. So that was a successful situation of getting a stay. Although, of course, I mean, this hasn't happened yet, but individuals in this circumstances could actually be detained, although they can't be removed. So getting a stay doesn't necessarily change the fact that your client can be detained during this process. So I think that's about all we have. We have some resources on the slide that we just want to highlight for you, some sample documents and sample stays of removal that you might find helpful, a guide to obtaining release from immigration detention. And that's pretty much it. I don't know if Becca, you have any kind of like final thoughts on stays or anything else that you feel like we didn't quite highlight, or anything else you want to flag about your program or anything else?
No, thank you for inviting me. And I just want to say to everybody attending, I don't know, obviously, everybody's reasons for being at this training. If you are in this field and you're interested in doing this work, I really invite you to get involved. Playtime is over. We are in a crisis. The situation is absolutely dire. There's not enough people in private or nonprofit practice doing this work. You can reach out to me. I'm happy to assist and give you materials and templates. Let's take these clowns to fucking task, man. I'm sick of it. And that's it.
Such a great way to end. Thank you for that. I appreciate that. Thank you, everyone. And just a final reminder, we hope to see many of you at our convening conference in San Antonio, Texas at the end of May. Registration is open, and we'll be actually having a similar panel on this topic, probably with some updates in a couple months about what's going on. So hope to see many of you in person then. Thank you all for fighting the good fight, and we will talk to you soon. Take care.
Recording stopped.